All right. Good morning, everyone, and thank you for joining us for this first meeting of the task force to study transparency standards for state's attorney. My name is Charles Sidnor. I serve as one of the chairs of this committee. And just to give some background before I have our co-chair introduce himself and say a few words. By way of background, this particular task force was authorized by the General Assembly's Chapter 141 of the 2022 session laws. We are tasked with studying the possibility of establishing minimum transparency standards for Maryland state's attorneys. The law has charged us with examining existing policy of state's attorneys' offices across the state that relate to transparency of data, charging of crimes, and sentencing, developing processes by which prosecutors can collect information and determine what should be made public and what should remain private, and sharing our findings and possible recommendations on potential changes in law regarding the expansion of prosecutorial data collection and reporting in a report due by this year's end. Me, along with our chair, we certainly look forward to working with everyone on this committee and hearing some really important presentations in the next meetings to come. With that, I would like to turn it over to Delegate David Moon.
Thank you, Senator, and thanks everyone for joining this morning on this endeavor. This is actually not my project. I was conscripted by the Senator into his brainchild here, to be clear. So I have no prejudgments whatsoever about what we should recommend. And so I'm really coming into this with an open mind and hoping to learn from all of you about this topic. But I'm always interested in data and learning from it. Candidly, the context from this legislation, if you recall, this was from Senate Bill 763 from 2022, and it came out of a time when we were looking at a range of data for judges, prosecutors, and the like, and there was a lot of conversation about that. And this is one of the pieces that popped out there. To be clear, we are just talking about pulling together recommendations that may go into law, then get debated through the normal legislative process. So we're not actually making any decisions here. Just to scope out the work for this task force, we went to the plain text of Senate Bill 763 for this. And as the Senator outlined, we tried to decipher what the law says we should be talking about. And it outlined 4 things in the text. Again, I'll reiterate them. The first was just to figure out what the existing data release policies are, to look at recommending processes for this, including a discussion of what should remain public and private, and to try and make overall recommendations on what the transparency over charging decisions, if any, should look like. So that's the scope of the work here. And again, I have no prejudgments, very much looking forward to the presentations and hearing not just about what the best practices are, but what's technologically feasible at the moment or in the future, because I know that's been something that's held back some of our previous discussions and desires on this topic. So with that, welcome and thank you everyone for joining.
All right, so next what we'd like to do is just have everyone who's a part of this committee introduce themselves so that we can all have a better sense of who you are. So with that, I will look to my screen and go across Senator McKay.
Thank you, Mr. Chairman. Welcome, everybody. I'm Senator Mike McKay, representing District 1. That's Garrett, Allegheny, and Western Washington County. Look forward to hearing the discussion and working on this topic. Thank you. Thank you, Mr. Chairman.
Thank you very much. Mr. Gibson, Rich Gibson.
Good morning, everybody. My name is Rich Gibson, State's Attorney for Howard County, President of the Maryland State's Attorney Association. It's my pleasure to be here. Thank you, Mr. Chair and Delegate Moon and everyone. I'll be presenting today, so you'll hear my voice quite extensively for the next few moments. Again, pleasure to meet you, and I'll look forward to talking to you soon.
Thank you. Miss Nancy Faulkner.
Hi, good morning. I'm Nancy Faulkner. I'm the Deputy State Court Administrator at the Administrative Office of the Courts for the Maryland Judiciary. Thank you for the opportunity to participate, and I look forward to the work we're going to do.
All right, thank you. Delegate Valentine.
Yes, thank you, Mr. Chair, and good morning. My name is Delegate Valentine. I represent District 2A, which is Eastern Washington County, as well as Northern Frederick County, and happy to be participating. Thank you.
Thank you very much. Ms. Lamone.
Good morning, everyone. Linda Lamone. I am an ex officio member of the task force and representing the Attorney Grievance Commission of Maryland. And I look forward to working with all of you. Thank you.
Thank you. Dr. Soule.
Hi, good morning, Senator Sinor. Good morning, fellow members of this committee. My name is David Soule. I am the Executive Director for the Maryland State Commission on Criminal Sentencing Policy and look forward to participating on this task force.
Thank you. Ms. Heather Warnken.
Good morning, everyone. Heather Warnken. I am the Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law, and really grateful to be a part of this important work.
Thank you. Mr. DeRay McKesson.
I'm DeRay McKesson. I'm the Executive Director of Campaign Zero, an organization focused on ending police violence and mass incarceration.
Great. Ms. Mona Sahaf.
Morning, everyone. Mona Sahaf. I'm here from the Vera Institute of Justice. Happy to be here. Good morning.
Good morning. Mr. Love, Davon Love.
Good morning, this is Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle out of Baltimore City. I'm actually in the process of moving in settled, so I'll be off camera for a little bit. And once I get settled, I'll be back.
Sounds good. And we also have with us Mr. Stephen Kroll.
Good morning, everyone. Mr. Chairman, I'm Stephen Kroll, the Executive Director of the Maryland State's Attorneys Association and the State's Attorney Coordinator for Maryland.
I jokingly say that's my favorite prosecutor in the state.
Thank you for the compliment.
And Mr. Stephen Roberts from Vera.
Hey, everybody, thank you for having us here. I'm with Mona. I am with the Vera Institute of Justice.
All right, thank you. So what we have planned for today are two presentations, one from the Maryland State's Attorneys Association to give us a better understanding of the type of data and the like that is collected by our state's attorneys' offices. Then we have a more macro look at best practices and those same types of data from Vera Institute. We believe at our next meeting, we're going to be reaching out to our court system to possibly provide a presentation on this index system, as well as some of the vendors who provide case management system to our state's attorneys' offices. So with that, we would like to go ahead and move into these presentations. After we have the presentation, we can then move in. I would assume the best thing will be to allow our presenters to give their presentation and save questions till afterwards. Then we'll take those questions. So we'll start with Mr. Gibson. The floor is yours.
Thank you very much. Again, Rich Gibson, and as was stated, the goal for the presentation today is to give you a better understanding about what we as prosecutors do, how it all works, what as it relates to transparency. So what is currently in place as well as transparency? I'll also discuss some issues or challenges that the task force should be aware of so they can craft recommendations, if they choose to craft recommendations, with an awareness of some of the issues that exist within the field. A little bit about myself quickly. I am a career prosecutor, been a prosecutor for 19 years. Started off I went to Howard Law and then clerked for a judge, and then started off in Prince George's County under Glenn Ivey, did district court there and juvenile court. I was the head of the juvenile drug court. In 2006, went to Baltimore. I was in Baltimore City State's Attorney's Office for 12 years. 5 of those years were spent in homicide. Another 5 of those years were spent in major investigations, where I handled, obviously murders, but also organized crime cases, gang cases, human trafficking cases, large-scale drug cases. Ran for office in 2014, lost. Went back to the city, ran for office again in 2018, prevailed, and became state's attorney in Howard County, Maryland, which is, what I consider to be the highest honor, the thing I'm most proud of in my career, representing the community where I live, and shaping justice in this space. After being elected, I was elected by the electeds. There are 24 state's attorneys in the state of Maryland. We have an organization which you'll hear from Steve Crow, executive director of, which is the Maryland State's Attorneys Association. The elected state's attorneys, as well as the U.S. attorney, the state prosecutor, and the attorney general are the prosecuting entities that make up the Maryland State's Attorneys Association. They elected me to be their president, and I'm in my 2nd term in that role. So that's a little bit about who I am. That should give you kind of a background or a lens as to, who I am and the perspective I bring to the field. Can you all see the presentation right now? Excellent.
No, not yet.
Can we put the Senator Sidnor? I believe the presentation was shared with Ms. Rossmark yesterday. Does she have access to it?
And Mr. Gibson, this is Claire Rossmark. You have been designated as a co-host. Can you share your screen? Because we feel that's easier just for you to administer.
Let me, I am savvy in all things trial, but as far as tech, I call in help. And so let me call in some help quickly. Forgive me for the delay. I thought I had a misunderstanding about how I was going to proceed. Let me get some tech help, and then I will absolutely do that. Give me one moment. I apologize for the delay.
No problem.
The bat signal went up and help is on the way. And so they're coming now.
It's all good.
Appreciate it. All right, so we're gonna be the ones displaying it. Let me get out your way. You can set up so that I can display it. All right, awesome. Can you all see now?
Yep, it's up.
Excellent.
Thank you.
Don't go too far, because if I get in a sticky point, I may have to call for help. All right, so everyone can see, correct? Just make sure that we're good. Perfect. All right, so let's begin. Make sure I can advance the slides. Use a clicker. Did the slide just advance? Excellent. So the topics of discussion today are going to be transparency as it relates to, again, what exists currently, transparency as it relates to charging, discovery, trial, sentencing issues, and then other issues or challenges in the field that I think you should be aware of. and relating to charging decisions, right? Charging decisions are how an individual is formally informed the state is alleging they've committed an act, and it's how the justice system attaches a connection to an individual. Each state's attorney, there are 24 of us, has their own office policies as it relates to charging. Their policies vary by jurisdiction and reflect the community they serve. Part of what the elected officials, these attorneys, campaign on is their vision for the office, their vision for what justice is, and the policies they will set. And so it changes with every election cycle, assuming if the state's attorney stays in power, then those policies tend to run, they tend to continue. If is a change in administration, then those policies change. An example would be in Baltimore City. Ms. Mosby, State Attorney Mosby, had policies that said we will not charge certain kinds of offenses. All right. There's a whole bunch of factors that factor into the race outcomes, political race outcomes. But the Carson attorney, Ivan Bates, campaigned on not wholesale, not pursuing cases based upon the type of crime, but pursuing cases based upon the actual strength of the case and whether it should go forward or not. So the category of crime was not an issue for candidate, now State's Attorney Mr. Bates. It was an issue for State's Attorney Mosby. Mr. Bates won the election and changed the office policy as it relates to what crimes were charged within Baltimore City. So it varies with each jurisdiction. And one moment on that, I'll spend a moment on that. We are not meant, under the Constitution of Maryland, State's attorneys are not intended to be a one-size-fits-all. We are very much intended to reflect the jurisdictions that we serve, that we're beholden to, and the community kind of drives that. And that is a good thing because it ensures that the community voice rings loudest in relation to justice and how it's administered in that location. If you look at a state like Florida, for instance, where that's not the case, where the Constitution was structured differently, the governor has actually done this, but the governor can say, I don't like your policies, you are removed. And that could be for political reasons, it could be for other reasons, but the governor has the ability in Florida to remove a state's attorney and replace them with someone who mirrors their policies, effectively disenfranchising the communities that voted for that state's attorney to put in place the policies that state's attorney had put in place. And so Maryland does not function like that. State's attorney is an independent executive official, beholden to the community they serve. The policies they set, the vision they craft, mirrors that of what the community wants. And if they don't want it, then they get voted out and replaced with someone who does share those beliefs. Statement of charges, which is the actual document that alleges the crime, is a public record, so it's shared publicly. The indictment, any serious case that the state is proceeding on, generally speaking, is indicted, right? In the 24 jurisdictions, the vast majority of them proceed that way, right? And that indictment, the actual allegations are a public record. The grand jury process, the process of investigating a case and determining whether probable cause exists to proceed, is secretive. So that part is secretive, and it's secretive purposely. There's two reasons behind it. And the first reason I'll address quickly. Second reason I want you to really hold on to, because I'll come back to it later on. First reason is that without secrecy, the allegations could damage the reputation of the individual being investigated. And I'll give you an example. If it was alleged that person X was a child molester, right? And that was the allegation. And we had some evidence of that. We presented that to the grand jury. If there wasn't secrecy around that, the 23 members of the grand jury, and they're comprised of 23 members from our community, that hear the facts of the case, are informed of the law, and decide whether probable cause exists for charges to move forward. Probable cause being facts and circumstances give rise to the belief that a crime may have been committed, and the defendant may have committed the crime. If they had heard that and they could share that, the allegation is incredibly damaging. If it's untrue and unfounded, that would if it's shared, it would be crippling to that person's reputation, right? That person's job might be affected, the person's family might be affected. There's an allegation of child molestation and it's untrue, unfounded, and yet shared. That would be a real problem. And so the grand jury process requires secrecy for that first reason. And the second reason is that behavior of individuals change when they know they're being monitored. If there's a long-term investigation into a gang or into a group or into an individual, and that is a grand jury original, meaning that that case is proceeding from the grand jury, before the grand jury first, that would be, if the person knew they were being watched, they would change their behavior, right? A clear example of that in terms of human behavior would be if you're driving down the road and you see a police car in the median, you tend to make sure that you're doing the speed limit as opposed to racing by. If for the parents here, if you tell your kid no cookies till after dinner and you're standing in the room, your kids tend to not go after the cookies because they know you're there and you just told them no cookies. If you leave the room and your children are mischievous like mine might have been when they were younger, then they might sample a cookie. But the point is that your behavior changes when you're being monitored. And that second point, I'm going to come back to later on in this discussion. The discovery process. The discovery process is how we share the information that we have related to a particular crime or an allegation of crime. And that is codified under Maryland rules. There are two rules in particular that codify them, Maryland 4262 and Maryland 4263. 262 is for district court discovery. 263 is for circuit court discovery. Again, discovery is the process in which the state shares what information it has related to the criminal conduct of the individual. It's a very complex rules, but it really boils down to three things that are shared. Any information the state has that they wish to utilize to prove the defendant is guilty, they must give over. Any information the state has that would undermine the assertion the defendant is guilty, that would exonerate the defendant, or that could be used to show the defendant is not guilty, that we're having possession, we have to turn that over, to give it to the other side, the defendant. And any information that we have that would undermine the credibility of a witness, the state intends to rely upon to make their case. We have to turn that over. So that could be a prior criminal record for a witness we're relying on that impacts on their credibility or truthfulness. It could be the fact that we know the witness described something incorrectly or a system that's inconsistent, we should turn that over. So these are the discovery rules that require us to give to defense everything we have. So that's a pretty transparent system. Infractions of this are something that attorneys really seek to avoid. Your license is potentially jeopardized. Certainly your employment in the state's attorney's office could be jeopardized. Certainly your reputation would be jeopardized. And possibly you could face demotion or termination if you were to not properly handle the information before you. And so there's a lot of tools in place to ensure that prosecutors are complying with the discovery rules and giving over what they're supposed to give over. There are some challenges. The state is responsible for all information. When I say the state, I'm not about prosecutor, the state's attorney. The attorney assigned to the case to prosecute the case is responsible for all information related to the case. And their job is to ask their law enforcement partners to provide that information to us. And we routinely ask that, collect it all, and then give it over. There have been times where, and it's rare, but it happens, where you ask for everything. They give you what they believe to be everything. They, being the law enforcement agency you're working with, gives you what they believe to be everything. But, something wasn't included, or something was missing, or something wasn't, and the prosecutor is still on the hook for that. Even if they weren't aware of it, it's not the same as if they were willingly hiding something or something that's malicious, but it has the same impact. It impacts the admissibility of the evidence. It impacts the case, and it could impact that prosecutor's job. So that's the discovery process and some of the consequences that come with it. States offers. So most cases are resolved with a plea. That's the reality. And I want to talk for a moment about how pleas are fashioned so you can understand the transparency that exists in that space. All 24 jurisdictions utilize the Maryland State Commission on Criminal Sentencing Policy Guidelines, right? We just call them the sentencing guidelines, as the basis for generating pleas for circuit court cases. All right. So that's the basis for the offer that's made to the defendant, right? And that is not mandatory. It is something that is a recommendation, but in consulting with my other state's attorneys, everyone I spoke to uses the Maryland guidelines, sentencing guidelines, to create their plea offers. This is important because the guidelines are racially neutral on their face, gender neutral on their face, religious affiliation, sexual orientation, national origin, any demographic fact you might want to point to is not a factor that is overtly considered in the guidelines. The guidelines turn on two things, and it's going to get mathematic for a second because I'm going to call back your grade school Cartesian charting. If you ever did geometry when you were younger, there's an XY axis, just a grid I'll show you. And on the X-axis is the offender score, which is what you see on the left. And on the Y-axis is the offense score, Y being vertical, X being horizontal. The offense score. And what it really boils down to is on the offender score, how bad of a human being have you been, right? So what's your past criminal history? And then on the offense score, the seriousness of the crime, how horrible or how bad on a scale of negative was the actual instant offense you committed. And those two things create a number. So for the offender score, if you look at the chart on the left, again, we're looking at how bad of a record does this person have. Were they being monitored at the time they committed this action, right? If you weren't, it's a 0. If you were, it's a 1. Juvenile delinquency. If you're 23 years or younger, it can be calculated. If you're 23 years or older, juvenile delinquency is a non-factor. But essentially looking at, in your recent history, if you were recently a juvenile, how many times were you found involved in a delinquent act? So how pervasive has your criminal habits been? Do you have a prior adult criminal record? Were you on parole? And did you violate parole previously? That's what's considered in your criminal history, the offender score. So how bad have you been is the X, and on the Y-axis, it's the seriousness of the actual events that occurred. Was the victim injured? What kind of injury was it? Was it permanent? Was it temporary? Was there no injury? Was a weapon used? Was a gun used? Was the victim that was harmed particularly vulnerable? So, if the person was of tender age, if they were a juvenile or a child that was harmed, or was it someone who was elderly that was harmed? Or was there some kind of mental incapacitation of the victim that you preyed upon? That goes into creating a number for the offense score. Those two are used to generate, again, the Cartesian charting, right? X and Y axis, generate a range on a grid. So let's say you were a moderate criminal with a moderate crime, right? So let's say you were a 4 and a 4. Go backward. So if you're a 4 and a 4, your offender score is 4, your offense score is 4. Your guideline range would be, I know this, 3 to 7, right? So 3 to 7 would be your guideline range. And so that means for the crime you committed, we would fashion a plea that was between 3 years and 7 years. Now, where do you land in between the 3 and the 7? Depends on the strength of the case. So let's say we have a case where we have a ton of evidence. There's video evidence, there's DNA, there's fingerprints. There's a confession. It's open and shut. And what you did was absolutely horrible. Not absolutely horrible, but for the crime committed was as bad as it could be. Then if the guideline range is 3 to 7, our offer would be 7, right? If our case is weaker, the witnesses are unreliable or not completely reliable, the evidence is shaky, we're not 100% sure about, we believe they did the crime, but we know there are challenges to some of our witnesses because our witnesses aren't as safe, they aren't as, we're relying on people that aren't as they come from sketchy backgrounds, let's say it that way. Then the offer might be 3. But either way, the boundaries, the upper range and the lower range are set based upon the guideline range, which again, on its face, does not take into account any of the it's not black, white, political affiliation, gender orientation, sexual orientation, national origin are not variables in crafting this number. And all 24 jurisdictions use this approach. For guilty pleas, assuming that a guilty plea is conveyed, right, the offer is conveyed, the process in terms of transparency in the process there, we share with the defendant. That is then put on the record in a courtroom. So when you go into court, the prosecutor will call the case and will put on the record the offer. The defendant on the record in a courtroom, creating for public view, will either accept or reject that plea. Assuming they accepted the plea, then what's called a plea litany is engaged in, where the defendant is walked through all the rights they are giving up and acknowledging the consequences of taking the plea. The court, the judge, has to be satisfied that the court can reject the plea. It doesn't happen often, but the court has the ability to say, I reject the plea, I'm not taking this. So the court can say, no, I won't do this. It's too light or too heavy, or I just don't like it. Judge has the ability to do that. Assuming the court says, I'll entertain the plea, this process is engaged. The defendant is walked through the rights, the right that you're giving up the right to call witnesses, you're giving up the right to challenge the evidence, you're giving up the right to have a jury impaneled if it's a jury case. If you're a foreign citizen, because that's not a factor so far. If you're a foreign citizen, you understand that pleading guilty may have an impact on your citizenship, and you're informed of all of these various things, and you have to acknowledge that you understand that and wish to go forward. I say you, the defendant has to acknowledge that they understand that and wish to proceed. And the court has to be satisfied that plea litany is knowingly, intelligently, and voluntarily accepted by the defendant. That's all done on the record for the whole universe to see. So it's an incredibly transparent process from that perspective. The state then has to explain the underlying facts that support the crime which the defendant is pleading guilty to. If the judge feels that the facts aren't met, the plea falls apart and it goes away. There's something called a not guilty statement of facts, which is it's not done a lot, but it is one way that cases are resolved, where the defendant is saying, I believe the state has these facts, but I believe you'll find me not guilty upon hearing them. And the state then lists out the facts, and the judge then decides whether the facts support a finding of guilt. If they do, then the case proceeds. If they don't, the judge can simply get rid of the case, goes away. The case will be non-prossed or dismissed. But the court has to agree that the facts which were provided on the record before the universe support the conviction. Once the conviction is secured, there's a sentencing guidelines form which is filled out, right? And that the prosecutor's office, state's attorneys are conduits to that information. In other words, we help fill out the document, but the document is not ours. The document belongs to the Maryland State Commission of Criminal Sentencing Policy. That document has demographic data on it and the facts of the case in a more, I don't know, analysis-friendly way, right? Already went through that. So for instance, for the Maryland Sentencing Guidelines, the defendant's name, their gender, their birth date, the jurisdiction where it took place, the date of the offense, the date of the sentencing, so you have an idea of how much time lapsed, the number of criminal offenses they're being convicted of, the type of plea it was. An ABA plea is a plea where everyone agrees, so the state, defense, and judge. A non-ABA plea is where the one of the parties, state, defense, or judge, does not agree with the does not agree to the plea, basically, is not joining in the plea, but you're still moving forward with the plea. A plea no agreement is what I described, like a not guilty statement of facts. Trial with a court, jury trial. It covers representation. Did the person have a public defender? Did the person have a court-appointed lawyer? Did the person represent themselves? Were they a private attorney? Their ethnicity, their gender, and the offenses. It also captures remember I took the XY chart previously? It captures that data on the section that's displayed here. The overall guidelines range, I'll speak to that for a second. Again, all this is done on the record before the universe, so it's completely transparent. Let's say someone committed 3 car thefts, right? So there are 3 different victims who've been harmed. And so there's 3 different crimes, one to each victim who owned a vehicle. And let's say the guideline range was, we'll just do the same one we used before, 4 to 7, right? The overall guideline range would be a minimum of 4 if the judge ran everything concurrent. And because there were 3 victims, a maximum of 21, which would be if the judge ran those sentences consecutive, it could be 4 years to 21 years because there were 3 victims, because there were 3 separate crimes that are captured on this sheet or in this offense. And so that's captured there. That's the data that's captured on that form. You also capture victim information is captured on the form. So was the victim present? Were they unavailable? Were they notified? That information has to be filled out, and that's filled out by us. Sentencing departure information is filled out by the judge. If the judge decides to go above or below the guidelines, they have numerical codes that correspond with the rationale behind why they deviated from the guidelines. They can write on the form. There's a narrative section that describes the offense and any terms. Person's put on 3 years probation, whatever. It's kind of written on the box you see on the right side of the screen. The prosecutor who's in the courtroom will write their name on worksheet completed by. They'll put their title, which is typically ASA, Assistant State Attorney, and the judge, they'll write the judge's name. They then hand that to the judge, and the judge will sign the document, and then the document gets sent to the Maryland Sentencing Commission. Other issues that we should consider when considering recommendations to make to the legislature. So, case management systems. Within prosecutors' offices, there are 3 primary case management systems. It's not just limited to 3. There are more, but there are 3 big ones. What we refer to as PBK, often also called Carpel. Prosecutor by Carpel is one case management system. Judicial dialogue is the other. We use that in Howard County, so I'm familiar with that one, and we use that in Baltimore City as well when I was there. And Software Unlimited is the third. A couple of things that the task force should know. First off, not every jurisdiction has a case management system. All right. And talking to my fellow state's attorneys, I know that in Talbot County, they're trying to get it. They don't currently have a case management system. Not all jurisdictions use the same software. Obviously, there's 3, but there are others, but these are the 3 dominant ones. The jurisdictions that have this software could have the same software, but could use it in different ways, with different kind of priorities, and also think of it like a car, different options, different bells and whistles that come at additional price So for instance, Baltimore City uses JD and Howard County uses JD, but the systems, while the same system, it's used in somewhat different ways. And not all the software has the same capabilities. So not all the software has the same interfacing capabilities. In terms of what software is used and how robust it is, there are a couple of variables. One, the elected state's attorney has to choose that software, has to say this software fits our needs. So each jurisdiction, all 24 of us, decide this fits our needs. Or in Talbot's County case, they're trying to get it, but they don't have it yet, and so they don't have a case management system. But the elected state's attorney has to say, I want this. It's what we need. And then once they choose it, there's a financial component. The county executive or executive entity for that jurisdiction has to agree and put that in the budget. And then the county legislature or whatever legislative body in Howard County, our county executive would have to say, I agree with the attorney's request. I'm putting that into our county budget. And then my county council would have to approve the funding for that system. So it's a three-step process. The state's attorney, elected state's attorney, has to choose the system and say they want it and what they want, how robust. Because again, you could have every bell and whistle, or you could have, half of them, something more basic. And then the county executive has to make that part of the bill or part of their request for the budget. And then the county council or whatever entity the legislative body is has to fund it. The legislative body has the power of the purse, right? And so that's an issue that you should all be aware of in terms of the way things actually work in terms of logistics of getting it done. And the other piece is that the case management systems, I'm starting from the bottom up, what you see on your screen now, the case management systems that we have are not really designed for statistical purposes. I'll speak for Howard County now. Our system is designed to track case progression. It's designed for internal guidance, and it's designed for community interaction. A lot of agencies have similar purposes, but that's the way we use our system, right? And I'll give you an example. If a constituent called the office and said, I didn't like the way my case was handled, I wasn't treated fairly, I'm a victim, and what the prosecutor did was wrong. That's a very important thing for me to examine, for my office to examine. And they would be referred to either my deputies or myself. And the very first thing we would do would be to look up the case in JD, which is the system that we employ, our case management system. And we're looking for our system is based upon a narrative history. So it's not yeses and nos, not radio boxes, it's not something that can readily translate into data points. It's a narrative script that the prosecutor who's assigned the case writes in when they say, so let's say the person was alleging the plea offer was never communicated to them and they didn't like the plea the defendant received, and they're upset that he was offered that plea. I'd look back, and what I'd hopefully see is that the prosecutor assigned the case, reached out to the victim on numerous dates, and has recorded, I reached out to the victim on this date, reached out to the victim on this date, spoke with the victim for 30 minutes, talked about X, Y, and Z. That information should be listed in narrative form. When they did, what was covered, what was discussed. And that is what I would use when speaking with that victim. I'd say to the victim, if the prosecutor did their job, I say to the victim, Mr. Victim or Miss Victim, according to our records, the prosecutor spoke to you on 5 different occasions. On 3 of those occasions, they conveyed what the plea was and how the case was progressing to you. And you were notified of that as recently as the day before trial, right? Then we can have a different conversation. I'm sorry you're upset, but I according to the records, the prosecutor did what they were supposed to do. They informed you of the process. They kept you in the loop, and had that conversation. Or conversely, if my prosecutor did something wrong, apologize for the error, try to see what we could do to rectify the situation, and then have a conversation with that prosecutor to ensure that they are doing what they're supposed to do. And they face whatever consequences they face based upon the seriousness of the offense and the lack of proper reporting. But that's the way our system, our case management systems are used. They're used primarily for tracking case progression, internal guidance, and community interaction. Other issues. I couldn't find any jurisdictions. I didn't hear from everyone, but I heard from almost everyone, all the other 24 jurisdictions. From those that I heard from, the majority do not employ statisticians. I could not find anyone who did employ statisticians. I can't say all didn't because I didn't hear back from everyone as to this issue, but I can say that the overwhelming majority do not have statisticians on staff. So we don't have someone who's tracking numbers on staff. No one indicates that they track wins and losses. So we're not tracking like guilties and not guilties. We're not tracking that data. Not all jurisdictions have public facing websites. So we do in Howard County, right? And I guess another point to make is that although not everyone has public facing websites, those that have public facing websites have different levels of interactivity with that website. Some are kind of like just a landing page where you can just go to get some other information to kind of be referred elsewhere. Others are more robust. Like in Howard County, ours is very robust. It has case updates and all kinds of information on it. It's updated daily. But other agencies don't have a more static page. Some agencies don't have a web page at all. And so sharing information with the community is not done via that medium. Again, not every jurisdiction has a case management system. And as I said, the case management system that we have is designed not for statistical tracking, but for internal guidance, case progression, and community interaction. So one of the most important things that I want to caution our group about that is a real pressing concern of mine that I hope the task force will embrace is I'm not against statistical analysis. It is beneficial, but we must avoid that analysis perverting justice. The state's attorney's office, these attorneys must always be paramountly focused on doing what is right. Justice has to be the focus. That could be null processing every single case. That could be proceeding on every single case. But if you keep stats, right, you are creating a scoreboard. And if you create, let me say it differently. Not if you keep certain stats, or if you keep a record of those stats, that could create a scoreboard. I'll say it that way. And if there's a scoreboard, you are incentivizing the prosecutors to chase a good score, right? And that could pervert justice, right? I should not be concerned about having a good score. I should not be concerned about having a 90% conviction rate, right? My job is not to convict. My job is to do justice. Sometimes that means conviction, right? But if you're keeping track of scores, you're incentivizing. We've been students for a very long period of time in our life. Everyone in class is taught to seek the A, right? We're elected officials. And so our ability to, provide for our families, right? And the prosecutors as well that work for us, the ability to provide for their families has to be tied and tethered to doing justice, not having a good score, not having a good number to reflect what you're doing, right? And that can be very corrupting to the system. In order to keep your score high, you could choose to not take on the challenging cases that should be taken on, or you could choose to offer lesser potential criminal sanctions for horrific behavior because you want to secure the good, quote unquote, good score, the good outcome. That is incredibly dangerous. And I'll give you an example, and this is routine. This is on a monthly basis, we're seeing it numerous times. He said, she said rape, right? And he said, she said rape. We see him again. This is unfortunately part of our society. We see it all the time. Regular thing. It's not like a rare occurrence. He said, she said rape. The guy saying it was consensual. The girl saying it wasn't. Their DNA evidence is of no moment because both agreed that the act occurred. So the presence of DNA, irrelevant. Both agree sex happened. It's simply whether consent was given or not. Most sexual events occur in private spaces. There were no other witnesses. It's two people in a room. One person comes out saying, I didn't agree to that. It was horrific. My life is forever altered. The other person saying, this person was a willing partner. And it comes down to the credibility of the witnesses. It comes down to whether you believe what victim is saying or you find more compelling what potential defendant is saying. Those cases are always challenging. Getting 12 jurors to agree X happened or Y happened is an incredibly daunting thing. And I can tell you that the stakes are high because if someone did something like that and they're not held accountable and they're not stopped, there's a fair chance they'll do it again, right? And conversely, if the person's innocent, that allegation is particularly crippling and challenging to an individual. These are very high stake cases. Prosecutors would shy away from them if there was a data that said, you tried this case and you lost it, you're getting a lower score. It's affecting your conviction rate. And so no jurisdictions that I spoke to are tracking that kind of data. I would vehemently argue that whatever policies you enact, avoid anything that would create an incentive to chase a score, because that will be corrupting. Next slide. So there are other agencies that collect data, data that can be mined to help guide legislative actions. And I'm not opposed to data. I just am opposed to data being used a certain way in our field. And that's just want to be very, very clear. One of those agencies, and we have representatives on our task force from both these agencies, which is great because they can inform us about that in greater detail. But the Administrative Office of Courts and the Maryland Sentencing Commission on Crime Sentencing Policy, MSCCSP, both have pools of data they aggregate related to some of the things that the legislature and this task force might be interested in. And I would say that from a fiscal perspective and from a logistical perspective, it would be an easier lift to modify already existing data sets, data pools, data aggregators, than to create a new data aggregation collection source within these attorneys' offices, the 24 attorneys' offices of the state. And so if there's information that the legislature is looking for to assist them in shaping what laws they recommend, I think that these two agencies might be a better place to mine for data because they already collect a lot of the information that we're just conduits for and don't really collect. Again, our system is relatively transparent. There's always room for improvement. I'm not saying we're perfect. And I'm willing to have discussions with this task force and the legislature eventually based on recommendations that have come out related to what those transparency standards and changes look like. The policies are again set by each state's attorney, so they vary jurisdiction to jurisdiction, and they vary by prosecutor in that jurisdiction. If there's an election that changes, all the policies related to that office change with the election because the community has said we want something different, and our job is to be responsive to the communities we serve. And so the policies that we set are reflective of our communities, and we're designed to be that way. State attorneys' offices are designed in the Maryland Constitution to be 24 independent executive entities that shape criminal justice to the will of the communities that they are directly elected by. And then my final point, again, I don't want to belabor it, but I really do believe that scorekeeping is dangerous, right? And that whatever we do, whatever we recommend, we should like vehemently avoid anything that would create a score related to prosecutor has this many prosecutors this grade, 90% of our conviction rate or 70% of the conviction rate, because if you give those numbers, you are going to make people chase the high score, and chasing that high score could undermine justice. Our goal must always be to do what is right as it relates to that case, not to seek a particular outcome based upon the grade associated with that outcome. And I would also add that while you can try to explain away stats, and stats can be spun and twisted and modified, I get that, and you can always have explanations. The assertion is always more compelling than the explanation. The explanation is long and dry. Build a wall is quick and easy and overly simplistic, but it's catchy, it stays in people's minds, right? That kind of logic is dangerous. Not to get into politics, but that kind of logic is dangerous. We need to avoid simplistic reductions and examine it from a broader perspective. And with that, I conclude my presentation, and Steve Kroll and I will take any questions you might have. Thank you.
Thank you so much. Would you mind turning your screen share off for the awesome? There we go.
That worked good. I'm not.
You got that part down like a pro.
Yep.
So we're gonna take questions now. I just have your presentation actually was very helpful, and it raised a lot of clarity for me, at least, about one direction this conversation could go. So I guess if folks will indulge me, I have a couple of questions that I want to kick us off with. And I want to start with a question about, by and large, I think your point about scorekeeping is good and interesting. I would think some of the data already exists for some of that scorekeeping, like we see murder closure, case closure rates, and things like that discussed in the press for some jurisdictions. But the piece here I am curious about isn't much about grading people, but deviations from the guideline to me is sort of an interesting thing, and how case outcomes land on that spectrum of, the range of a sentencing guideline. Where someone lands on that is an interesting thing. So if they're within the range, sure. But if they're not within the range, that to me is a curiosity if that's tracked within, like, do you as a state's attorney know within your office whose work is leading to, varying outcomes and things like that. And part of the question I would pose there too is, does it help this conversation if we start to make a distinction about aggregated and disaggregated data? In other words, is there less fear about this sort of data if it's compiled either on a statewide, county, or court jurisdiction level, and not a single prosecutor is being tagged, to the data? The Sentencing Commission, I'll note, in its mission statement, while we respect the local discretion, and that's sort of built into the system, specifically has the goal of using this information to help reduce unwarranted disparities and to ensure these sentences are proportional and fair. So I would just throw that out there as our entry question, that with this sort of framework of existing data and guidelines and these sort of goals to at least be aware of what sort of disparities might exist and deviations from the guidelines, does it help the conversation at all if we start to move into a world clearly of talking about aggregated data, not individual to specific prosecutors?
So there's multiple questions in there, Delegate Moon. I'm gonna try to answer them as completely as I possibly can, comprehensively as I possibly can. So your first inquiry related to like office policy and departures, right? Again, all 24 jurisdictions use the guidelines as the benchmark for what their pleas are offered. I'll speak specifically about Howard County. If we're making an offer we are a guidelines community, a guidelines county. My office, we make offers within guidelines. So if an offer is made by us, it is, the guidelines are the floor and ceiling that drive that offer, right? And the prosecutors in my office generally are not making offers outside those guidelines unless it was something exceptional, right? And so I'd say the overwhelming majority of in our community, the overwhelming, I'm talking like 98% of any offer that would be conveyed is indexed to the X and Y chart I showed you earlier in the presentation. Judges can deviate. So if the offer was, sometimes what will happen is a defendant will plea, we call an open plea. So an open plea is when all the terms of the plea agreement are not defined at the time the plea was accepted. So in Baltimore City, for instance, historically, I only did closed pleas. I did not do open pleas. So when I made you an offer, it'd be like, you committed a murder, I'm offering you life suspend all but 30 years. Very specific offer, right? Here in our jurisdiction in Howard County, more frequently, it'll be you're pleading guilty and there'll be a floor and a ceiling set. And the judge determines that floor or that ceiling, right? As opposed to, and the floor and the ceiling is tied to the guidelines, as I said to you, but the judge can go beyond that if they choose. If they do, the judge fills out the departure code, and that's reflected on the bottom of the guidelines form. So that's first part of your question. As to the data aggregation, yes, caveat. So yes, if it was not as to the specific prosecutor, that's good. However, there are 24 elected officials. And so if it went to the county level, you would create the same pressure because no state's attorneys want to retain their positions, and they're going to create the rules by which all attorneys that work for them must follow. And so if you were to aggregate it on the county level, you would create the same scorekeeping. If you're tracking data down to the county level, you'd create the same scorekeeping problem in that if in the end result, it's going to spit out saying Anne Arundel County has a 60% conviction rate. I'll use myself, I won't use anyone else. If you said Howard County had a 60% conviction rate, that would be antithetical or a negative that would impact my ability to be reelected to this position. And it would be a negative on me. And since it's a negative on me, my office is not going to employ a strategy that allows for that. And so you're going to create the same pressure if it was done at a countywide level, right? Because in the end, the state's attorney would say, well, we can't risk any dangerous cases. And look, I'll give you an example. Our federal partners do this. Our federal partners are known for having conviction. Feds have a 90% conviction rate. They talk about that all the time. They have a safety measure. If they don't take the case and they turn cases away, not attacking my federal partners, just speaking generically, they turn cases away all the time because they're just like, it's not a slam dunk. We're going to turn it away. They allow the state to take those risks because the state don't track those measures, right? And so the state is more accepting. And I'll give another issue. The state is the final say. So there is no. If we say no, we will not prosecute this case, it's too tricky for us, or it's just, I don't think we'll win. Although I believe you've been harmed. I believe it happened, but I'm worried about not winning. And I'm worried about the score that will be reflected if I don't prevail. There is nowhere else to go. That victim simply goes back out into the community. The criminal who committed whatever act is still back out in the community, and nothing has been done to make our community safer or to make that victim whole. And so we are the final catch. And so it's another reason why it's important that we not create those kind of benchmarks. Now, data at a statewide level, if you look at data, if it's just aggregated to the point of statewide, Maryland does this, that is less dangerous because it doesn't impact anyone directly's livelihood, right? And so that's something that I think we should examine and think about.
Okay, if any other task force members have a question for Mr. Gibson, if you want to raise your virtual or real hand, we can call on you. I think I saw Nancy Faulkner and then Davon Love. If you want to go in that order.
Thank you. Mr. Gibson, could you share a little bit more about the other entities that you were suggesting manage this data instead of it being based on state's attorneys? Just hear a little more about your thoughts behind that, please.
Sure. So the AOC, Administrative Office of Courts, does hold some of the data that we collect, right? So like the information that's filled out in sentencing guideline forms, the Maryland Sentencing Commission and the AOC have those records, and they do manage those, not necessarily in the way that they do manage that information, not necessarily in the way that the task force. I don't know what task force is envisioning, so I can't really speak to what we envision yet because I have not heard that articulated. But those entities already have and retain these data sets. We are conduits for the data, right? Like we fill out forms and then pass them on to other entities who house and use that data however they house and use that data. We don't do that. Like I don't track the national origin or the race of defendants. I don't track, I don't even track like the case outcomes like that. Like we don't have a conviction rate, right? Like I'm not looking at that.
Okay.
I'm looking at doing justice. Just each and every case, universe unto itself, what is right?
Okay.
What should we do?
So with the Sentencing Commission, they may have more of that. I don't think that the judiciary tracks all of that data that you're mentioning, but the Sentencing Commission, that's a very good point with that. Thank you very much.
No problem. Thank you.
DeRay, go ahead.
Ms. Gibson, this was very informative. Is there another place outside of the individual prosecutor's office today that reports on any of the metrics around like prosecutions, pleas, or are we dependent today solely on the prosecutor's office to give that information publicly?
So I'm not aware. I can only comment on what I'm aware of. I'm not aware of what other entities do or don't do as relates to that. We share, my office, I speak for Howard County, we share data on a case-by-case basis. So there's, if there's a outcome.
When you say share, this is just a point of clarification. When you say share, you mean share publicly?
Publicly, yes, publicly. But we communicate publicly if there's a issue, a case that's of community import. So if we've had an increase in car theft in the county, and the police bring charges against a car theft ring, and that car theft ring is charged, we will share that information. I'll give you an example. We had Howard County is a relatively safe space, right? We had a gang that was operating in our community that was just and enlarged itself, and it was basically occupying all of Columbia, right? Which is rare for a gang if you understand how gangs work. Because most community members in Howard County were numb, like you didn't know what to look for. Like you wouldn't know to look for the orange bandana. That orange bandana you saw tied on a light pole meant something. And so there's community import in sharing that, because now people know to be aware. If I see an orange bandana tied to a light pole, that's indicative of this particular gang tagging that space.
No, that makes sense. That's not my question, but that makes sense to me. I'm trying to understand better. It seems to me, unless there's something else, and this is why I'm asking you very earnestly, that the only way we can get any information about disparities by prosecutor, by race, by gender, by any of that, today we are solely dependent on the seeming goodwill of the individual prosecutor's commitment to sharing this data publicly. If not, I'm trying to understand who else might have the data to make it public, because your answer to me was you do it case by case, which is you seem to have a commitment to share the data, which is a good thing. But the next person in your role could not share that commitment. And then we seem to be hamstrung by the individual's commitment, which does not seem to me as like a systemic commitment to transparency. That is what I'm trying to understand better.
Got it. So yes, twofold. One, no prosecutor's office that I'm aware of tracks the data related to race. So no one is saying, I am collecting data, I'm observing a data set for this many Black defendants versus, we're looking at cases. The race of the defendant only is relevant if it's relevant to the case. So if someone says I was robbed by a white guy, I want to make sure the person that we've charged isn't a Black guy, right? Because the victim said I was robbed by a white guy, right? So the race is only relevant as it relates to the case. It has no relevance to our offices outside of that narrow parameter of case relevance. And so no office I'm aware of is tracking that data, Mr. McKinnison, like related to that particular topic.
Yeah, that is my, we can debate like whether it's important or not, but I think you would agree that if there was an office that only charged Black people, that would be important to know. And I hope that we would agree on that point as a matter of demographics. But I'm just trying to understand, and it seems like the answer is no, that there is no third party that is not the prosecutor's individual office that currently reports this data across the state. That is what I'm trying to
If I can just say one thing to Mr. McKesson on that is, a majority of what prosecutors get is from police who do keep that data. We have very few investigations that start with us and end with us. Usually, I'd say 95 to 98% of what we get is from police, and they keep the data. And then the court, meaning the court system, gets the data on sentencing guidelines. So what we get as far as an individual independent investigation, not from the police, is very, very little, very little. So the police get that when it comes to race statistics, and the court then gets it from the Sentencing Commission. So we get very little initiation of investigations on our part, just to tell you.
You know, Mr. Crow, what you said makes also total sense to me. What I am reminded about the unique power of the prosecutor's office, right, to actually decide to move forward or not, and that does seem to be in your purview. And it is undeniable that there are decisions about race and gender that just happen, whether they are, you know, I'm neutral about why they happen. I'm just saying like they do happen. And trying to surface where that data is what I'm trying to get to, just as a matter of the data, not anything else around it. But I appreciate the context.
Yeah, so just so I can respond to that, like I believe in systemic racism. I'm not saying that race doesn't play a role in things. I'm saying that the process we utilize is race neutral. And as Steve said, the police have, you know, arrest data that they can disaggregate related to race. The courts have conviction data that either Sentencing Commission and or administrative officer courts can disaggregate as it relates to race, but we don't track. My whole point was that we don't track that measure. It's not something that we don't examine that part. We only look at race as it relates to the strength or weakness of the case in terms of does it match what the victim described? Is race even relevant? It might not be relevant in some cases because the victim never said my assailant was Black or my assailant was white or my assailant was male or female. I mean, when they say those things, then it becomes relevant for our perspective as state's attorneys.
All right, we've got a series of hands. We'll go Davon Love, David Soulé, and then Heather Warnkin in that order.
All right, thanks, Mr. Gibson, for that presentation. I hope you can hear me. Given the rubric that you described, that you all use to base the proposed plea, and the offender part, where you take in consideration previous charges, I think a lot of us are aware that particularly majority Black communities are more policed in certain ways than other communities. And there are ways that folks' exposure to law enforcement and the criminal justice system makes it so that folks who may have repeat convictions has more to do with their race and where they are, where they live, than who they are as an individual. Have there been conversations amongst prosecutors about ways to rethink that rubric in a way that considers some of those dynamics? And if they have, can you just kind of speak to some of the nature of those conversations? And if not, what would you think would be helpful in spurring those conversations amongst prosecutors?
So several things. Thank you for the question, Mr. Love. So again, I'll answer it in reverse order. So each prosecutor's office, again, the prosecutor that is in charge of that office, that shapes the vision of that office, is elected by the people of that community And so their individual policies are going to vary related to the community they serve and what the community values are in that space. So for me, I've launched diversionary programs, and I take a holistic approach to charging, and I take a holistic approach to evaluating the criminal act, right? And that takes into account those variables that you're touching on. That reflects the mindset of my community. My community in Howard County is very law abiding. They're intolerant to crime, but they're also they have a progressive lean, right? We are a democratic community, and my values and my administration reflects those sorts of approaches to crime. There are other communities that embrace a different perspective, and not necessarily a racist perspective, just a different perspective on crime and how it should be approached. And the change that happens in those spaces is driven by the community itself, because every 4 years, they can vote in someone who runs on a campaign of, I believe in X versus Y. Or they can say, no, we like Y. This is what we want in our space. This is how we want justice to be administered here. And so it's really reflective. The policies that are imparted that you're touching on are very much reflective of the communities that elect the prosecutors.
Hey, Missy, I just want to zero in because a part of my question is about whether or not there is conversation amongst prosecutors about these dynamics and the role they play and how they administer the rubric. So I'm just curious about if that's a conversation that has happened in any formal or informal sense, and what is your sense of the nature of those conversations?
So through the MSAA, we certainly have those conversations. We've had implicit bias training that was implemented. Professor Richard, what was his name, Steve, that did it for us? He prepared it for us. Do you recall Richard? Steve, you recall his name?
Don't offhand, I'm sorry.
There's a professor at University of Maryland. First name is Richard, which is the same as mine, which is why I remember it. The last name begins with an M, but I can't recall. McMillan, maybe? I can't recall it exactly. But a professor at University of Maryland comprised a implicit bias training for prosecutors. It wasn't just a generic implicit bias training. It was geared around prosecution. And so, yes, we have these conversations informally, and we have had them formally as it relates to the task of how we look at cases, how we examine cases, the offers we make. It is something that we have discussed, yes.
All right, Mr. Saleh.
Thank you, Delegate Moon. So I just wanted to chime in quickly. Just wanted to offer clarification for something that was mentioned earlier. The Sentencing Commission does not collect charging data. So I think that was a miscommunication. So we wouldn't have the data to be able to calculate, for instance, conviction rates. So that was something I just wanted to offer clarification regarding.
All right, Heather Warnken, and then we'll circle back to Nancy Faulkner.
Thank you. And thanks so much for the very informative presentation. I have a kind of a comment first before a question. One is just kind of bringing to the committee's attention, for those who aren't aware, there was a robust report done by the University of Maryland's Criminology Department in 2022, focused on racial disparities in prosecution in Baltimore. And that's, of course, one of the top criminology programs in the country. They really did a deep dive, and there are a number of findings and recommendations that I think are, very directly related to this conversation today and the work of the committee. But in particular, there's a section on data recommendations, and there are 3 categories: existing data quality, recommendations for the need to collect additional data, and then recommendations for integrating data systems across case management and some of these other entities to do better analysis. And a part of why it's really on my mind with this and the recommendation around better collection of race and ethnicity data. And I'm recalling that I think there was something in the recommendation because, as you've said, it does the prosecutor's office might not be set up for this, and they're relying for something very important like defendant race and ethnicity data on police reports, like recommended better collaboration with police departments to have more consistent tracking of those things, because there is, an important body of research that suggests that not only the race and ethnicity of the defendant, but also race and ethnicity of the victim has an impact on discretionary decisions. So I just wanted to kind of bring that to everyone's attention. And then relatedly, so my question, it definitely stood out to me when you were describing how most of these offices do not have a statistician. They don't have a data person. And I heard your point loud and clear about, the focus on each individual case, and it's about doing justice in that individual case with this information. But I'm especially given sort of the trend and national focus in criminal justice more broadly to have data-driven practice and to really be able to lean out from the view of individual cases to look at trends, disparities, but also trends related to resource allocation, et cetera. So I'm curious, like, your take on the sort of statewide look. Are individual offices trying to do that in-house? And especially given the lack of a data person, like, who is mining what limited information that they do have at the individual office level, if anyone?
So again, no one I spoke to out of the 24 had a statistician, so no one has it. Again, having any resource is a function of funding. If there's funding for it and there's money that's given to us, certainly we might have an army of statisticians looking at all kinds of data. But we have to, our primary task is doing justice. We always seek to do better justice. There's always room for improvement. I don't think you ever quit on that. And I think data is an aspect of that. I'm not in any way shying away from that. But again, it's a question of when we have resources, we have to decide how we're going to use resources, and we have to ask and get funding for those resources from our communities. And so that is part of the challenge there, Ms. Morgan, is that we just don't, typically speaking, you're looking for bodies to handle the cases, paralegals to process the cases, investigators to help you gather the evidence when the police can't, or to investigate police when we're investigating them, support staff to handle all the administrative tasks. That's sort of the layout. I have a staff of 92 people. That's what the county gives me budget for. And we're laser-like focused on doing justice in the community. I'm not saying statisticians couldn't be part of that argument to address your point. We don't have the resource allotted for that at this time.
Our offices are county funded, not state funded for the most part, except for grants and things like that. So we're dependent on the local jurisdictions we're just dependent on the local jurisdictions for our funding.
Can I ask a quick follow-up on this? Thank you both. That's helpful. I'm wondering, so there's obviously a resource challenge to staffing that function, but if the resources were there, like, is that a priority? Is that, because I'm trying to sort of decipher the message or the takeaways from the presentation about whether or not that's of interest, but you don't kind of have the existing capacity, but that's something that you want, versus reasons why that might not be a priority.
So I think it's a priority, but there are you're balancing a series of priorities. So shrinking the caseloads of our prosecutors so they can actually put more attention into people talk about public defender caseloads. Every case that exists in the criminal spectrum, a prosecutor has. So our caseloads are, typically burdensome. Getting more prosecutors to reduce that caseload so they can actually put more attention to each case is a huge priority. And so that's just one among many, right? So yes, it's important. If you're telling me would I make it, if you gave me the list and said make it 1 or 5, it'd be lower on the priority list. It wouldn't be at the bottom, but there are certainly, if you gave me money, if I got money from my county council and I had to choose how best to use that to effectuate justice in my space, statistician would not be my first choice if that's what if that's what you're asking. But it is important to us.
Thank you, folks. We'll have obviously more meetings and opportunity for additional online and offline questioning. In the interest of time, we do have one other presenter for the agenda. So I did want to see if we could pivot to that, if folks are ready to transition to the next stage. It's Mona Saha from the Vera Institute to talk about best practices when you are ready.
Hi. Yeah, I'm very ready. Let's go. Thanks so much, everybody. And Rich, thanks for that presentation table setting. I appreciate it. Let's just introduce ourselves. I'm going to pass it over to Steve Roberts, who's also here from Vera to introduce himself, and then I'll go after Steve. Steve.
Thanks, Mona, and thanks for having us here. I'm Steve Roberts. I'm the Associate Director for Research on our Reshaping Prosecution Initiative at Vera, which means I lead all the research team, a team of 7 qualitative and quantitative researchers for our prosecution team. And my background actually is in software development, so I have some familiarity with software systems too. Back to you, Mona.
Thanks. I have to brag for Steve. Steve's helped a lot of prosecutors all over the country, small counties, large counties, figure out how to get a CMS going, help them extract their data and look at analytics. So he has a lot of experience, and hence why I did drag him to this meeting. And for myself, Mona Saha, I'm from the Vera Institute of Justice. A little bit about my background. I'm a former federal prosecutor, first at the DC U.S. Attorney's Office, which is not a state, as folks know. And so very much like a regular DA's office, we handle all of the violent crime from misdemeanors all the way up to homicides, sex assaults. I worked there for 6 years doing a lot of general crime work, doing domestic violence work, also doing national security work. After that, I went to Main Justice DOJ headquarters in the criminal division to what's called the Human Rights and Special Prosecution Section. There, I traveled around the country investigating, prosecuting crime in districts everywhere, which is a very eye-opening experience because I just don't have that kind of view from DC, which is overall a pretty liberal jurisdiction, but a lot of racial disparities and other disparities. Going around the country was really an interesting and eye-opening experience. So I have that background as well. From there, I kind of did everything from, complex fraud, homicides in Indian country, anything where the U.S. had a connection to international crime at our embassies and military bases as well. After that, I was also at the Treasury Department briefly, and then came over to Vera 2 years ago. And now Steve and I and our team, we work with prosecutors all around the country on a lot of different policy issues, but certainly also a lot of work around how to collect data, how to clean your data, how to be more transparent around your data, and how to use your data to help your office make better decisions. So with that, I will share my screen. Thank you, Claire, for the hosting permission. So I think really wanted to level set around to start, whether we should be collecting this data or not, which I think is kind of on the table for this task force. Why should prosecutors be collecting data? Is that a good use of their priorities? As Rich noted, there are many pressing priorities for prosecutors. And I think, though, there's a really strong argument for why people in government need to be collecting data and looking at their data so that they make more effective decisions. And it's a threefold reason, I think. One is in-office efficiency. The resources are scarce, and I can say from what I've seen around the country, including in Maryland and including all my friends, all my former prosecutor friends, those resources are not building. They are constricting in certain ways, and it's very challenging for state's attorneys right now because a lot of people don't want to be in court every day. They don't want to be in the office every day. The pay scale is what it is. And so we need to be doing really good work, but really doing it more, doing it smarter and sometimes with fewer resources. So to be efficient in terms of the use of the monies that you have and the staffing that you have, you need to be looking at your own office data to see where you need resources, where you can cut resources, what's not working well. Efficacy, and pardon my icon, I'm realizing now it looks like I'm shilling for the Target Corporation, but I was just looking for something to make the point of about your targets hitting. Are the policies that you put in place working? To Rich's point, let's say you have an upsurge in certain types of crimes, or you find that certain crimes, there might be drug legalization, different things happening in different districts. You need to know if the policies you're putting in place are having their intended effect. And you cannot know that unless you're looking at your data and measuring and checking. So let's say I'm feeling that a lot of the victims are not coming forward in certain cases, they're not showing up for trial, and I put in some policy in my office to try to do better outreach to that community, to make it easier for victims to come to court. Maybe I get a child care voucher. Is the program working or not? Are more victims coming in? Are they coming to trial? You don't know. So you can't measure whether or not what you're trying to do is working unless you're collecting data and then looking at your data. And thirdly, last but not least, justice. The job of every public servant, no matter what sector you come from, is to deliver justice. And that means making sure that everyone in the community, every zip code member, no matter what you look like, no matter what your income is being treated justly and fairly. You don't know if you're doing that unless you're collecting data and you're looking at the data. And I wanted to turn to a couple other really important sectors that I think are similar to prosecutors that have deep impact on society's health and well-being, and look at some of the lessons we can take about the fact that they collect the data. Despite these really good points Rich is listing about the scare, being nervous around scorecards being used in a bad way. The thing is, we need accountability for our public actors, particularly when they have a lot of influence. I started looking at my kids' schools here in Maryland and all the data that is collected and published, and they're very far along in the process. So they're not where the state's attorneys in Maryland is going to be if this task force decides to make recommendations. But, someone said at the start, I think maybe it was David Moon, whether or not you all make recommendations. So that's why I think we need to come to thinking about coming back a bit to say, should we be doing this or not? Here are some of the questions they're asking in the education space. Every day, every year, what are our children learning? Are they learning enough? How do we know? If not, why not? And what are we going to do about it? And it's called evidence of learning. And this is data that you can find on the website. They are collecting on all types of measures, including disaggregated by race and ethnicity and gender, and by who gets a free lunch. There are statistics around how large the school classrooms are. They are putting out tons of data. And it does mean you can compare county to county, but it's so important to share this data so that they know what they're doing and they can be honest with parents and other stakeholders about what they're doing and what's working or not, that they put the data out there. So it's only by looking at this data, and it's in the aggregate. I think Rich's points are very important, that we want to make sure we're not necessarily judging individual prosecutors on the line against each other. That might be something internally, like Rich in his office might internally want to know, hey, which prosecutors are carrying the most cases? Wow, this prosecutor in my office, their cases aren't moving. They might need some extra supports. Those are things you're going to want to know for your internal efficiency. But in terms of what's put out to the public in the aggregate, yes, it does tell a story about where the resources need to be, where the problems are, and how you can fix them, because educators' job is to make sure that they're meeting everybody. And because they're collecting over year after year after year, then we can see trend lines. Which direction are we going? Are things going up? Are things going down? Are the resources we're putting into place working or not? I went also in preparation for this presentation to Children's National Medical Center, which is an impressive facility on the DC side of the border, to look at some of the information they're putting out. They're collecting tons of information and they're publishing that information in the aggregate so that you know how the system is working. And you end up with these metrics that kind of give you different flavors, because the data can be carved up in many ways. And the data can be about how many cases are going to trial. It can be about how long it takes for a case from start to finish. There's data going to be, there's a lot of different data you can collect, but the different stories that you can tell kind of give you an understanding of, okay, well, what's actually happening in our systems? What is the experience like for the users, for the patients? Another really important reason people are collecting data, and we'll take, again, lessons from the healthcare industry, is because we're trying to devise solutions for the problems we face. So if your problem is opioid overdoses, if your problem is, and this problem is facing everyone right now, increases in a violent crime involving juveniles in certain jurisdictions, you need to know what the problem is and measure it and find out what the common factors are to devise the proper solutions. So you have healthcare providers who are seeing, oh, there's a lot of firearm injuries and they're connected to certain sociodemographic factors. I think the second study is incredibly interesting. Racial disparities in pain reduction for minority children. That is central to the mission of any healthcare provider, is managing pain. And if you know that you're not actually delivering that on that mission, you're not actually properly managing pain for a certain segment of your population that you're there to serve, that's a problem you need to know. And when we do this research, we end up coming up with answers around what our problems are. So coronavirus, we're all too familiar with the coronavirus. And we think about the reasons certain communities are seeing upticks in cases. There are so many reasons. Do they not have masks? Are they not vaccinated? Is it an education issue? Is it a will issue? But when you do the studies and you look at the data, you can find out what's really going on. And that's the only way you can figure out what the real antidote is and deliver on your mission. Here, from research from Children's National, they found that one of the reasons that children from minority communities had the coronavirus in higher frequencies is because their parents were frontline workers. That tells you a huge part of the story that you don't know absent looking at your data, and then you can come up with a proper solution. Now, turning to prosecution, I think it's very similar to the education space. I think it's very similar to healthcare. Prosecutors' decisions have incredible impact. Prosecutors have a ton of responsibility and power. And I felt that when I was a prosecutor, my friends feel it, and all the state's attorneys here feel it. You're deciding, and I have on the left here, what is exclusively a decision that prosecutors are making. It's who to charge, because not everyone that the police brings is charged. The police bring certain cases that are not charged. So yes, that's where the cases come from, but it's not a passing of all the discretion from prosecutors to the police. That's not how this works. Prosecutors who are lawyers and trained and are deciding, as Rich noted, what the priorities of their office are deciding who to charge and who not to charge. They are deciding what to charge. This is also an exclusive prosecutor decision. Is it a misdemeanor? Is it a felony? Am I charging something with the mandatory minimum or not? And crafting plea offers is also, I'd say, a near exclusive prosecutor function, hopefully with some involvement of the victim. Of course, law enforcement is going to sometimes have a say. That's just the reality in terms of what happens. But truly, ultimately, that decision of what plea offer to extend rests exclusively with the prosecutor. So everything in green. On the right, we see decisions where prosecutors have a say, but not ultimate authority. And now it'll depend, though, depending on that prosecutor and that courtroom and that judge. Sometimes I was in courtrooms where the sentencing recommendation I made was very likely to be imposed. And I've been in courtrooms also where, the judge was doing their own thing. But prosecutors have a lot of sway and persuasion in the aggregate in general, in terms of who's held and who's not held pre-trial, and in terms of the sentences that are imposed. So like education, like healthcare, prosecutors and their decisions have incredible impact on the health and well-being of our society, both in terms of public safety, for all the victims, preventing re-victimization, and for all the people who are charged. We know from the growing body of evidence that someone referred to that the criminal system does have a lot of impacts on health and on communities in the long-term aggregate. And we're grateful for that research because it helps prosecutors understand the aggregate impact of the decisions, and the leadership, Rich and the other leaders in Maryland, helps them make decisions about what priorities they're going to have and how they decide what to charge. So just like all these other major industries we discussed, efficiency, efficacy, and justice in prosecutor's office will all be pushed forward in positive directions by starting up on more data collection, more data analysis, and also more data sharing. Talking about efficiency, like these are some examples of some of the questions that prosecutors, and again, Steve and I have worked with many prosecutors around the country who are trying to increase their data collection. And that includes some states that are poorer than Maryland and some counties that are smaller, and some counties that are larger. But there are all things we can do within our power. And it's incredible that this task force has been created because there's some energy right now. And I know there's also some public-private partnerships that are moving in Maryland right now. So there is energy right now around this issue. So this really might be the time to move. Some of the questions you'll be asking in your own office are, which staff needs support? Which cases need the most resources? Dismissals is a really interesting point that we deal with a lot of prosecutors on, and Rich can speak to this too. If you have a bunch of cases coming into your system that are being charged and then ultimately resulting in dismissals, you want to know why, because those cases are cases that maybe need not be charged in the first place, and resources should then be taken and put on the cases that do need more support. But you can't make intelligent decisions about how to deploy your resources if you're not tracking that data. Also, any prosecutor's office that wants to increase their resources, there are, I will tell you from having looked at DOJ grants, millions of our tax dollars that we all pay are funneled to the federal government, and then they put them out in grants at the state, local, tribal level. So there are grant opportunities, and they're from the private sector as well, that prosecutors can apply for. But you can't make an intelligent application if you can't say, hey, I'd like to apply, Rich talked about diversion, for example. I would like to do some mental health diversion or something with juvenile diversion. And these are the number of cases that we would be able to move into diversion theoretically, because these are how many juveniles we charge. This is how many cases have like a mental health issue. You can't actually tell in these grant applications what resources you need and how you'd use them if you're not tracking your own case numbers and data. And yeah, some of the grant applications out there are for smart crime, some are there to address racial disparities. So if an office is collecting on these metrics, it actually puts them in a better position when they're talking to their county executive about their budget, but also when they're going out after grants. And what prosecutors' offices are doing successfully around the country is going out for these grants and getting those resources in, particularly at this time when resources are limited. In terms of efficacy, serving victims, which is central to the mission of any prosecutor, is really emboldened by collecting data. From Stephen Jones, who's a prosecutor in Kansas, who was part of a working group that was working with some other prosecutors to build up his data collection. I tell the victims I work with all the time that if I knew what would work to prevent these crimes from ever happening again, I'd do it. But there's no way to know if you're not tracking it. Also, and maybe Heather raised this, in terms of victim characteristics, you want to know, how am I serving victims from certain zip codes that have, greater poverty, perhaps more joblessness, maybe less education? Am I treating female victims different than male victims? Am I treating victims from certain communities, Black, brown victims, differently than others? That's something you need to know. And to Rich's point, yeah, there are going to be some victims who are going to call the office and say, hey, what happened to my case? But I can tell you from a lot of experience working with a lot of victims, some victims do not advocate for themselves that way. No state's attorney's job is just to react to the phone call. You need to be doing justice in every case, including for those victims who do not speak up for themselves and are not advocates for themselves and do not have the time and resources to call their public official. You need to be yourself looking and saying, how am I servicing these victims who come from the worst places, who have the most challenges? What are we doing for them in our cases? And in terms of efficacy and delivering safety, this is also central to any prosecutor's mission. So there's a prosecutor's office in Minnesota every year, so they are collecting data and they're able to look in the aggregate of their data. And then there's some decisions they're making on their own. For example, they look at all the DUI cases they have, all the driving under the influence, driving while intoxicated cases they have each year. And they look to those cases, then they pull the files and actually look at the paper and see which establishments are involved. And they find the top 3 or so establishments where there are a lot of patrons leaving and then getting involved in DUIs. No matter what your interest is in terms of reform, safety, prosecution, we all want to reduce drunk driving. We all want to reduce those fatalities and those injuries. It's some of the most, horrible things that can occur when people are out there driving intoxicated. And they are doing outreach to those 3 bars and restaurants and saying, hey, there's a lot of patrons coming from your places and they're involved in cases that are coming to our office. You need to do something about this. You need to be educating your staff at your establishment about how to deal with patrons, when to cut people off. So yes, it's really important for us to do good work after a crime occurs, but really our mission, as your mission as prosecutors, my prior mission, was to prevent crimes from occurring again and again. We want to stop victimization from occurring. Yes, we have emergency room doctors. Yes, we have literacy specialists for when children are suffering and not doing well, but we need to be doing that preventative work on the front end too, preventing these cases from happening. So by looking at this data, you're able to prevent DUIs from occurring next year. That's a really beautiful, use of data. If your mission is around domestic violence, you want to know where are your victims coming from so you can deploy resources to them. And as I said before, if you're introducing a new policy, you can only measure if your policy is working or not if you're looking at the data. So again, to deliver safety and to see if you're making progress in your goals, whatever your goals may be. As Rich noted, different states attorneys run saying, my goal is to reduce X, my goal is to increase X. You can only let people know if you're doing well if you're collecting the data and sharing it. And that might feel scary, but it's something you have to do. Like when I'm voting in Maryland, I need to know who I'm voting for and if they're actually delivering on their promises, but they can't tell me if they're delivering on their promises if they're not tracking their data. And last but not least, justice. And I will say there is a lot of demand out there for folks who recognize how in the criminal system, in the aggregate, there's a lot of racial disparities there. And they are really baked into the system. Something we focus a lot on in VEER is trying to get people actually not to focus so much on individual bias of prosecutors. It is an important thing to focus on bias. And of course, we don't want bias in our system. And so I applaud everyone doing bias trainings and educating their workforce about how important it is to recognize one's own bias and what those techniques are you can employ to reduce bias. But the reality is we have many, many deep racial disparities in the criminal system that do not result from individual prosecutor bias. I think to Steve Kroll's point, this is coming in on the arrest side. Society has baked into it in this country a lot of racial disparities. It's in wealth, it's in education, it's in jobs, it's in your criminal history. To another task force member's point here, Drug use is very equitable in this country, or illegal drug use between Black and white folks, for example, but there are certain folks who are being prosecuted for it more. And it has to do with where the lens of police is. It has to do with resources that folks have. I tell people all the time, my kids, they're not getting caught up in the summer in certain things because I have them in camps in the summer because I have those resources. But if you come from a family that doesn't, yeah, your kids are out and they're not being watched. And so income and education and resources, really, it's really resources. It affects everything that's coming into the prosecutor's office. These are disparities that are baked in. So I actually believe prosecutors are able to take the pressure off themselves and educate their communities and their stakeholders in a much better fashion about the fact that I am not trying to overcharge Black people, brown people, poor people, unhoused people. These are what's coming in on the front end. These are the disparities that are coming in, and let's work together to address those disparities. So these are examples of some prosecutors around the country who've looked at the data and then implemented policies to try to ameliorate the disparities that they see. Up top, trying to increase juvenile diversion, which when you look at data is often offered more often to white children than to Black or brown children. That's something a prosecutor wants to know and maybe do something about. And in Colorado, they've been able to not only use that data to inform their policies, but then also look to see what happened after we implemented a policy. And here you can see they were collecting data and they found that outcomes are better for defendants and for victims. In Michigan, we had a prosecutor who looked at her data and found that a gun enhancement was being used near exclusively against Black people in her jurisdiction, even though guns were possessed by Black and white folks in her jurisdiction. And she decided to put in a policy in place to work on that racial disparity. And in Minnesota, we've worked with a prosecutor who's looked at racial disparities in traffic stops. That's also something kind of in the water here in Maryland, at least in the county where I live. And trying to look at what the data said about why are we conducting these traffic stops, what evidence are we actually getting out of them, and how can I reduce them? He implemented a policy, and because he tracks data with some of his local police, 2 years after the policy was rolled out, he's able to say, we have reduced low-level traffic stops by huge numbers, racial disparities went way down, and they looked at two measures of public safety. One, 911 calls, and another, the number of guns they were getting out of these low-level traffic stops, and found no impact, no change, which everyone expected because the data has told us already nationally that these traffic stops aren't really promoting safety. But he was able to say all that. So he's able to decide, what problem do I have? What policy solution am I going to craft to address this problem? Now I know what it really looks like from measuring it with data. And then actually he was able to measure the data on his policy to see was it impactful or not. And was it having any negative impacts on public safety, which was very important to him as well. All things he was able to do because of data. So I was thinking of using a Halloween thing. I went with an art thing here, but sure. What are our fears about collecting data? Because that's real. One might be that the data is flawed and it doesn't tell accurate stories about our work. But in reality, the data isn't perfect, but it's still pretty good. And the data can tell us many, many things. I'll tell you, the school's data isn't perfect. Healthcare's data isn't perfect. That's something we educate the public and our office about and ourselves about. Sometimes the data is going to be incomplete, but there's still a lot of good information we get out of the data to make sure that we are, as I said, being efficient, being ethical, and delivering justice. Another concern might be that sharing data will invite unwarranted backlash from the public. But I actually believe, and we've seen this, that it helps us better collaborate with the public for them to understand that, as I said, and as Steve Kroll and Rich and others maybe have noted, these disparities are incoming into the prosecutor's office. This is what's on the incoming side. The thing is, because prosecutors have so much responsibility on their shoulders, they need to decide and know, am I passing through all these racial disparities through the system with my powers, which include stamping a person with a felony, pretrial detention, and incarceration? So I actually think communities can better understand that these disparities exist much more writ large in society, and that education, is possible, does work. And our fear of that shouldn't prevent us from sharing information because, the public has a right to know. You all are public servants doing this work, and we can't shield ourselves. Educators have the courage to do it. Healthcare has the courage to do it, and public servants in the prosecution space need to be doing it too. Another really valid fear is that collecting and publishing data will increase work for my staff. And I know we're going to continue to have discussions here about where this data exists and who should be doing it. But I will say that in the long term, as I've noted, Collecting data helps you deploy your resources much more tactically, much more surgically, helps you build efficiencies over time. There are offices that have restructured themselves and built in, for example, people working on data collection instead of on the line prosecuting, people screening cases instead of on the line prosecuting. That might be the better deployment of resources in your office, but you can't really know. Most of us, we walk into an office and the structure's there and it basically stays. So design of how you're prosecuting cases and what the structures are is really important. And leaders can only really like make bold, smart decisions if they have the data. There is a learning curve here. It does mean, like to Rich's point, and I've entered information in case management systems too, no longer typing all my stuff, but having to go to a drop down and say victim, Black, defendant, Brown. You're going to have to slow down and learn that new system. But overall, in the long run, it's going to be, there's fewer bad cases in the system. We're making smarter decisions. We're not wasting our time on cases that should never have been charged in the first place because they were never going to make it. And we only know that from looking at the data. So overall, this is going to help us save time. And now I'm going to get to my brass tacks, but I'm going to share this deck out. And I think Claire named that this will be also posted on the task force website. But when you're starting on data collection, two really important things are centralized funding and training support and ensuring consistent data entry. Maryland has, as folks have noted, 24 little jurisdictions of various sizes. Some don't even have a case management system. In order to do this well and to equip people to succeed, there needs to be some funding and training support in a centralized capacity so that people can train their folks up, get a case management system if they can't afford one of their own accord. These are some of the pieces I think it's important to make sure you're collecting at least one data point on. So that's total number of cases that come in from the police, charges at arrest. So those might be the police charges, the charges that come in on the charge sheet, like what they think there's probable cause for. The final charges that are actually charged, which cases coming from the police are declined, are not charged in the first place, which cases end up being dismissed at some point in their life cycle after they're being charged, and then cases resolved by plea and cases that go to trial. And this is really from our study and our work across the country with a lot of prosecutors' officers who are starting to collect data. You also want to be collecting details on the individual cases. And these are the 6 data points that I think are most salient from people, again, who have studied this and done a lot of work with prosecutors collecting around the country. What type of offense category it falls under. So you have a kind of limited number of categories. If it's property, drugs, domestic violence, homicide, sex assault, you have those categories. If it's a misdemeanor or felony charge, who referred this case, which law enforcement agency, because many offices work with several police departments, sheriff's office, sometimes the federal authorities are bringing you a case. The assigned prosecutor, again, that's really for internal case management. Defendant characteristics and victim characteristics. So race, ethnicity, gender, age, and zip code. And for the victim side too. It's I think crucial to collect on disaggregated race data. I will say from my work in this space, from my work as a prosecutor and also as a voting person in Maryland, who I'd vote for, I would absolutely want to be asking questions about what are you doing? How many cases are you charging? What policies do you have in place around women, around racial disparities? Those are questions I'd be asking my elected and anyone running for office. And in terms of choosing a case management system, I think Senator Sidner said you'll maybe be hearing from some possible vendors. In talking to Steve and others on my team, the kind of the feedback I'm getting and what we've seen from our work, working with a lot of different case management systems around the country, is any case management system can do the job or not do the job. It really depends on how you're entering data and what questions you're trying to answer. So you want that system to be customizable to what questions you want to answer for your internal office and for the information that you want to share out with your community. It needs to be user-friendly as well, because if there's too many fields, you're busy, I'm thinking of like myself going to someplace, my kids, and having to sign some waiver, and I'm just trying to scroll through and put my initials in and get through this process because I'm just trying to get done with the system and get my waiver signed. So if it's not user-friendly, people are not trained on this, and people aren't told from their leadership, this is why we're collecting this data. This is why this is important, you're doing it. People are not going to enter data accurately, and then we can't have as good data and make, do all these good things we want to do, which is make good decisions and, help our offices run more efficiently and get answers to the public. So that training up front is really important. Ideally, the case management system that you all choose will be able to receive data from older systems. So including PBK and the other systems Rich said Maryland is currently using, at least some of Maryland. And finally, Rich kind of touched on this, and this is very true. The data you put in for your case management does not necessarily marry perfectly with when you're trying to get that data out to put together reports, answer questions, share information. Those are separate things. Every management system will allow you to do it, but the ease with which it can be done is something you shall be thinking about. Vendors, might be incentivized to say that they can offer those services to you to help you extract that data and put out reports, but that will have different expense involved with it. So again, centralized support and funding at the state level would be useful to enable prosecutors to work with another state official and not with a private vendor. That would be ideal, but yeah. And for funding, there are grants available from the government, also from foundations and from the corporate sector. And there is some movement in Maryland presently to put grants together to help some offices get more data ready. University partners can help as well because they want the data. They also have a lot of experience, relationships applying for grants. So those are great people to partner with. They might be able to help you extract that data and clean the data and figure out how to put that data out to your community. And I did want to say that I have seen some jurisdictions around the country also work with their public defender service and get a case management system together because they have their own funding. That's another way that problem can be attacked. And with that, I think that concludes our presentation. Happy to take any questions and appreciate your all's attention.
All right, why don't we go ahead with DeRay with the first question.
Mona, this is really helpful. I'm interested to know where you think this collection of data is being done well, and or where you think it's being done well and useful, right? So I can think about places, I think about on the police side, there are a lot of places who have, use of force data that is interesting in spreadsheets and is essentially in a graveyard of data, right? Like it's in cool reports and informs nothing, right? So are there prosecutor offices, the only ones that come to mind are like, Cook County, I know they have a whole data team. Do you find that, is it informing practice or not? Or what is your perspective from a lens, a national lens?
Sure, no, I appreciate that. So I did kind of have ready to pull up the Manhattan DA's office dashboard. I like this dashboard. It's pretty evolved. And so I'm gonna stop sharing it. I don't want to scare folks. I'll put it in the chat in, but the point is that dashboard is very evolved and further along from where Maryland is. But I like their dashboard. But the reality is dashboards in our experience are primarily used by academics, by journalists and advocates. Okay. I am a mom with 2 kids in school here. I have never been to the dashboard here that I turned to for this presentation. That's just the reality. I'm trying to make lunches and make things happen. I don't actually go look, and I wish I had the time. So these dashboards, to be really frank, some prosecutors who have put dashboards together have found ultimately that the labor that went into it and the cost to build and then maintain has not necessarily given you the bang for your buck. But listen, for researchers and advocates, it is important. So maybe for some kind of longer term system change, it's important. What I think is, I am hopeful that the task force will come up with recommendations. Let's say we start collecting data and we have some publishing requirements. I think putting a report out once a year, and then each state's attorney, like Rich knows his community and his people, he could take that report to his people and explain it in context, or, someone who understands the data, whoever that person is. I know Rich brought someone in his office, maybe that person would help him. But the point is, whoever could help would actually help you go in the community and explain the data. But the data is not easy to understand absent someone actually walking you through it. And so we have this term, data walks. Yeah. So I don't personally know that a dashboard has to be part of this calculus. I think internally, I could see Rich and others wanting internally some kind of dashboard for themselves to see what's happening in my office, like what's happening with our cases, where are they going? But a public facing dashboard, I'll stop there, but could I see if my colleague Steve has anything to add there, Steve?
Yeah, and to be clear, my question was less about dashboards or the presentation of the data and more about the collection and use. So I'm neutral about how it is presented, but are there places that you found that collect data and use it in ways that they do like further the to Rich's continual point, which makes sense to me, the administration of justice?
Yeah, go ahead, Steve.
For a second, but you know, DeRay, you mentioned Chicago and Mona mentioned Manhattan, and I would say maybe Philadelphia is another one that's doing a pretty good job of data collection. I'm not really sure if they're all giving the, you know, the kind of, you know, the output, the analytics, the queries that are valuable to communities to help the communities hold the DAs accountable or understand what the DAs are doing, or not just the DAs or the prosecutors, but, you know, the whole legal system from police through prosecution, through probation, courts, and all these. But the thing about those three places is that they're all very big and very well resourced. So it's actually pretty hard. I'd say the only people, you know, some of the other places that have done well are the ones that have worked with us because we provide the resources to do the kind of analytics that we think are valuable, particularly to communities, and we do them in cooperation with communities. So to Mona's earlier point, I think it's going to be very hard for small jurisdictions or even medium jurisdictions to get that kind of work done without some sort of like centralized effort. And I think it's great that we're talking to a state task force here because it you know, the resources that a state can pull together are much greater than some small jurisdictions or even medium-sized jurisdictions. So I guess the short answer is it's not really being done that well anywhere, but the best places are the ones that have a whole lot of resources.
Yeah, and DeRay, thanks for rephrasing the question more pointedly for me, or, you know, repeating it rather for me. I'd say the place that's had the most impact is where the DA has the political will and is looking at the data and wants to do something about it. So either the DA comes in, they kind of ran on a platform like that, or they're in a community with advocates who are pushing them to do something. So they're actually looking at the data and being like, I saw this, now I'm going to make a change.
Awesome. Looks like we have Senator McKay with the next question.
Thank you, Mr. Chair. To be honest, I'm very confused over that whole presentation. That was just so much information that it was like trying to get a drink from a fire hydrant. And what concerns me of if we are looking for all of this data, the concern I have is, what do you do with it? Ms. Mona, I understood you to talk about the boards of education, just tracking everything. But then you said, as a mom who's busy with all the different things that you got to do, you don't go to the dashboard to find out that information. So what, you know, my end result is, well, if this information is good for researchers and advocates, how does it protect what the state's attorneys are supposed to do in protecting the public? And is the public going to go and look at all this information? You know, with Maryland, it was brought up that we have 24 different jurisdictions that get elected to represent the will of that individual community. It was made that in some of these places where it really, really works, the DA wanted to make a change. Well, if the state's attorney wants to make a change in Maryland in their individual jurisdiction, they run on that. And the biggest example is what happened in Baltimore City. It was a complete change. The public got to vote and said, we want a complete different way of looking at it. So I'm really concerned about return on investment. And while it may work in states like Florida when it's top driven, but when you have individual counties, and I can tell you in Allegheny County, what's important to Allegheny County is certainly not even important to Washington County, which is next door, much less what's down upon the I-95 corridor, being respectful of those being listed. So I just don't know how to wrap around, how do we make the public feel better about our system if it's just researchers and advocates that we're really presenting this for? And how does it change for the better of protecting the public, but also making sure that people are fairly taken care of through the justice system.
Thanks, Senator McKay. I appreciate the question. And I am sorry if this presentation didn't land well for you, and I am so ready to engage after this to answer any questions or provide any further guidance if it'd be helpful. So I'll say a few things. One is, this is something that gives me solace. My educators and my healthcare, when I say my educators, they are looking at this data constantly and making the decisions that are well-informed. And I know that in my county, they're looking at this data and making decisions about class size, about meals, about the curriculum, about making sure we're trending in the right direction on math and literacy. So when I'm choosing someone to represent me, I want to know, are they collecting data and are they looking at the data and are their policies data-driven? So that's what's important for me in my schools. That's what's important for me when I'm choosing a healthcare provider. And absolutely, that's what's important for many people in the public when they're choosing a state's attorney. How are state's attorneys explaining what the decisions are? So I absolutely think data should be shared with the public because the public has a right to know. The public has, and advocates and researchers are, as I noted up top, looking at data in the aggregate and then just helping prosecutors understand, hey, these are policies you can implement. I mean, Steve and I work with prosecutors all around the country who are saying, I have an issue with X, Y, or Z, and I want to work on it. And we're able to bring them a number of policy recommendations and practice change ideas and actually help them implement them in their office. And we've had a lot of success in doing so. And they're doing it because their constituents are asking for certain things or because they and their professional opinions are seeing issues that need addressing. But how could I go to any doctor or any teacher and say, what are the metrics? How are you all doing on test scores? How are you doing in terms of graduation rates? That's stuff that, of course, you need to know. So I'd ask you, like, how could someone not know those rates and know that they're doing their job well? How could I trust the professionals that we have in these positions to make these decisions correctly? But they have to know what's working and what's not. If they're not measuring, you can't really go out there and say, I'm treating everyone equally if you're not measuring race and ethnicity and gender. You can't know I'm making sure I'm delivering justice to everybody if you're not measuring race, ethnicity, and gender and dismissals. You have to be measuring those things to know if you're doing well. So I guess I'd ask, how could anyone say if they're doing well, if they're not measuring progress on what they've pledged as their priorities? And return on investment, I guess I'd say, I wouldn't see a dashboard as like the necessary end all, particularly at this juncture. You know, I think that if this commission was able to figure out which integers we want to collect on, which integers do we already collect on, I just need to like sew together and put out some kind of publishing requirement to hold everyone accountable, that would be a great thing. The idea that everybody has to buy the same CMS or pledge to making a dashboard occur in a certain time period, I don't know that those are the right moves at this juncture. But collecting more data and collecting it more accurately are absolutely within your sights. And it is, I'd say, very much the responsibility of prosecutors to do.
Well, to answer one of your questions at the beginning, I tend to believe that the sentencing guidelines removes all personal feelings. And when guidelines are based upon the record and the actual crime, there's data that has been collected all through those years. And I believe that Rich had made mention that it's more in the narrative. If you want to dive into individual cases and see why a case was not prosecuted or not, it's in a narrative, not in a scorecard. And so it'll be interesting as we go forward with this, but thank you very much.
Yeah, and I say also that there's a lot of focus on sentencing, but really what we're talking about is charging. The charging decisions are really powerful and they rest exclusively with prosecutors. So not everybody gets charged. A lot of cases don't get charged, and not everybody gets charged with a felony, and not everybody gets charged with the mandatory minimum. And it's prosecutors are deciding who gets charged and who gets declined and what charge to bring. And those things you guys are not collecting on presently or sharing out with folks. And that's where there's a lot of power. So sentencing is at that back end when honestly judges have a lot of power there. This task force is really about prosecutorial transparency, and the transparency be around those charging decisions on the front end that are incredibly powerful. And right now it doesn't sound like the public has any insight into how prosecutors are deciding who to charge. You know, there are campaign pledges you make, but then the question is, are they doing it? Are they not? Who are they charging? Who are they not charging? This is reality. Many, many crimes are committed that are not charged. It's just not possible. I worked in a very busy jurisdiction in DC. We did not charge every crime that came out. And the question is, how are you making decisions about what to charge and what not to charge? And it was not only based on the strength of the case. And I'm sure Rich would agree, like some cases are strong, but you're not charging the case because it's not a good use of resources. That's real. Yeah, the front end charging piece is a place where there seems to be a clear vacuum of information that the public doesn't have, and stakeholders and even offices themselves, it sounds like in Maryland, state's attorneys themselves don't have full insight into.
No, and I think it's perfect to highlight what you just said is, are the resources being actually applied and being well run? And I just have a different way of where the resources should be compared to asking for all of this voluminous information that you've omitted, that researchers and advocates are the ones that are really looking at it. And I just don't know how Joe citizen is protected by that. So it's something we can discuss. So
no, certainly. But again, to say, I want to know that my principal and my teacher are looking at test scores and making good decisions. You know, they are the professionals. So that's the thing. Like, I want my state's attorney, and I think a lot of people want their state's attorney to be looking at their data and making decisions based on that data.
Well, as a father of 8 who have lots of children in the system and that kind of stuff, it's not necessarily the test scores and it's not necessarily the data of the end result. I want the one-on-one with my child. And if I'm using resources to be collecting data and I'm taking away teacher-student ratio time together, then I don't believe that that's, so we agree, just a different way of getting to the same cost. So I shouldn't be occupying this much time. So thank you very much. Thank you, Mr. Chair or co-chairs.
Thank you. And I saw Mr. Gibson's hand up, but we generally do not have the panelists ask questions of one another.
I'll make it easy, Delegate Moon. I will refrain from asking questions or making comments.
Okay, great. Yeah, we'll have plenty of time for that. And we are running over on time here. So with that, thank you, everybody. We have a discussion of our work plan. Senator Sidnor, I'm not sure if you have more you want to say on the future work plan before we close out today's meeting.
Just and thank you very much for what you've done. The way the General Assembly operates on these interims, generally you're looking to have these types of meetings held on Tuesdays and Wednesdays. Our hope, again, because of such a tight deadline, was to try to get back together within the next couple of weeks. So if you all might be able to look at your calendar 2 weeks from now, which I believe is November the 1st. If that looks like a good date for you all, and we can try to have our next meeting scheduled for then. As mentioned earlier, we'd like to reach out and have some, as Mr. Gibson had mentioned, there are a variety of other agencies and things that have data and that we'd like to just to have a better understanding of what it is that they collect. Because again, as mentioned, the focus here is about prosecutors and the information that they have and collect and trying to get to the bottom of that. But also understanding what other information is available by the courts and within these particular content management systems, I think would be greatly helpful.
Senator Sidnor, what time on the 1st?
We try to stick with the same time if possible. How does that look for everyone?
I can make the morning work. The afternoon is preferable for me that day, only because I have some budget meetings in the morning, but I can make the afternoon work or the morning work if that's what works best for everyone else.
Right.
I can do the morning, but not the afternoon. Sorry.
So, Ms. Walken, were you about to say something?
Yes, thank you, Senator Sidnor. I was going to say there's an all-day victim services symposium in Baltimore City that day. I can speak with Monsi about the specific schedule and try to work around it if that's best for everyone, but wanted to let you know.
Okay. Anyone else? Other concerns? Yes, sir.
That's great for the morning. I have a 2 o'clock land use senatorial.
Okay, great.
So, you know.
Then let's schedule for 10 o'clock, November 1. And move forward from there. Mr. Gibson, if you can, if possible, again, I understand from your presentation, you have 24 jurisdictions with 24 different policies, but if those 24 jurisdictions have anything in writing regarding the policies that we're looking at, would it be possible to have them get those to you also, that we could at least have what they have in writing?
So, as you stated, not everyone has it in writing. Some would consider it work product and wouldn't want to share it policy-wise. Some policies, this was a comment I was going to make that I refrained from making. There are policies that we have that we don't want to publicize for good reason, right? One example would be prior to marijuana being illegal in Howard County for the last 5 years, or 4 years because it's legal now, we didn't prosecute any marijuana cases unless the particular offender was a horrific individual or the amount of marijuana was like a truckload. We literally had a truckload one time where we had to prosecute because it was just too much. But the general policy was to not prosecute those cases. They were abated by arrest, was my policy that I put in place. However, I never wanted to announce that policy to the public because I don't want to in any way encourage the use of marijuana. I don't want to in any way embolden individuals to use marijuana. And also the members of my community that would find marijuana handled in that way as not consistent with what they'd like to see. I have to organize my office's resources according to what I think is best. And so I chose not to prosecute those cases, but I wouldn't want to publish that, and publishing it could have a negative effect on me. And so we didn't publish it. So there are policies that we have that we don't share, is the point I was going to make for good reason. And so I can ask, but I'm not likely to get a robust response, Senator Sidnor. Many, I think, would consider that work product and they would not want to share it.
So even we have a federal Department of Justice that has a justice manual with a whole list of policies that we can find online. You're saying that the state's attorney's offices don't even have a list of policies as to how they deal with their data and transparency, or even
No,
how
in terms of not transparency, there's no policies related to transparency specifically, but like related to charging, for instance, there are policies that we have, some stated, some unstated. Some agencies have a written document. Candidly, I have a written document, right? We have an office manual, but other agencies do not. And it's not uniform. It's each elected state's attorney decides. The agreement that existed between Montgomery County and Howard County related to police-involved shootings before that was given to the AGs, prior to me, was a verbal agreement between John McCarthy and my predecessor. There's nothing written at all about it. When I got into power, drafted a document that guided our relationship with Montgomery County related to police-involved shootings that John McCarthy signed off on because I wanted something in writing, but not everyone does, is the point.
Can I just follow up on the senator's question there with a little bit of clarity? I understand what you're saying about the charging decisions and charging policies, but I guess if any of the offices has a written policy regarding data collection and data release, say like a PIA guideline on charging and plea info, on data policy, that would be of interest if anyone had that. And if they don't, that's fine too. But if there are written data disclosure policies already in place that anyone uses for anything, that might be a helpful starting point.
Absolutely. So I can ask that. I'm sorry, Mr. McPherson, you should respond to Delegate Moon for 1 second, and I'll respond to whatever you have as well. I could ask that question of the 24, whether they have any data disclosure policies. I know we follow MPIA, everyone does. So So that exists. But as far as anything separate from that, I can make that inquiry, and the 24 will hopefully get back to me.
And just to put a pin on that, is that if they don't, that is noteworthy too. If it really is like, if the prosecutor wakes up and decides that I want to make this one public, if that is the practice and the default policy, we should know that as a matter of the task force decision. If they really are if the majority of jurisdictions just do not have any actual policies and they are handshake agreements, backdoor things, or non-public agreements, I do think that is a matter of importance to the community for sure, and certainly the committee.
I can tell you that every office has policies that are orally conveyed. Every office has policies that are I can't say that. I can say every office has policies that are orally conveyed. I can say that most probably have some policies related to the structure and running of their office in writing. But as to the robustness of it, what's detailed, those are going to be decided by the individual prosecutor, again, based upon that community and what they.
That makes sense, and I think you must understand that if everybody's agreement is an oral agreement, that I don't know if I call that the most transparent thing to community, but I digress.
And we should really wrap also. We're sort of getting into extended substantive discussion here. We're trying to get closing notes.
Again, that, and I agree with Mr. McKesson. The absence of is important to know as well, again, because this committee is focused on prosecutors and the information that really is in your hands rather than the other offices. So if there's something that you want to talk about further online, we certainly welcome to do so, but we do need to get to the bottom of that. With that, I want to thank each of you all for your presentations. I would like to thank everyone who was here today with your time and your input, and look forward to seeing you all in 2 weeks. So thank you very much. Y'all have a great day.
Thank you.